Hello and welcome everyone. My name is Lalit Soni and you are watching Polity This Week by Drishti IAS. In this episode, we'll be discussing about certain topics from the polity, and these topics has been in news in the past week. So these topics can be important for you from the exam point of view. So let's start with the discussion. In this video, we'll be discussing about nearly 4 topics which are mostly related to your Supreme Court, Collegium System, money bill, etc. etc. So the first topic will be Supreme Court on money bill. Recently, there was this news which says that the Supreme Court will be considering cases related to the money bill, wherein they will see whether the path taken by the government with respect to the money bill, or you can say they have given the status of money bill to a particular bill to get it passed, whether it is right or wrong. You must have heard about the Aadhaar Act, etc. So these acts has been considered as the money bill by the speaker. So we will be scrutinizing that particular money way path. Okay, so that is there. Second topic will be Supreme Court's power of judicial review. When we are talking about the judicial review, you can say that it is a kind of check and balance system which is there in our governance. Okay. Now, when we are talking about the money bill, there is a particular power which is given to the speaker of the house, that speaker will decide whether a bill is money bill or not. Now, the thing is, this decision of speaker is basically totally you can say a power of speaker, and it is actually discretion to the speaker. But the thing is, this decision cannot be questioned in law. Now, question is whether such thing can happen in a system wherein we are talking about the checks and balances. Okay, so it is questioned that judicial review on the power of speaker can be done or not when we are talking about the money bill. So in that regard, we will be talking about the power of judicial review as well. Okay. Then moving to the Collegium and the new judges in the Supreme Court. Okay, recently there was this appointment of 2 new judges in the Supreme Court. Okay, when we are talking about the appointment of the Supreme Court or the judges of the Supreme Court, or the transfer of the appointment of the judges of Supreme Court or the High Court. Okay, so basically in short, if we say any kind of transfer or the appointment in the higher judiciary, if there is, then we are relying on the Collegium system. Okay, so we will be talking about the Collegium system in that. Okay, then Supreme Court seeks reports on the Gram Nyayalaya. Okay, so we'll be talking about this topic as well, that why Supreme Court has asked for a report from the states with respect to the Gram Nyayalayas, and what are the Gram Nyayalayas. Okay, so let's start with the first topic, that is Supreme Court on money bill. Supreme Court to hear petition on money bill. The Chief Justice of India agreed to list petitions challenging the money bill route taken by the centre to pass contentious amendments in the parliament. So basically there has been certain acts which has been passed as money bill, because you know that with respect to the money bill, Lok Sabha has more power and Rajya Sabha has limited power. So if you are not having the majority in the Rajya Sabha, in that case you will want to circumvent the discussions in the Rajya Sabha, and that is why the money bill status is given to a particular bill, so that Rajya Sabha will not have much say. Okay, when we talk about money bill, Rajya Sabha can actually you can say just suggest certain amendments, but it cannot actually you can say go for the amendment in the money bill. So that is what is there when we are talking about the Rajya Sabha and Lok Sabha. Money bill can only be presented in the Lok Sabha, that is there. Money bill is a government bill. If we talk about, only a minister can actually present this bill in the Lok Sabha. Okay, so there are certain things which are related to money bill which gives special status to the money bill. Now, which bill is a money bill? Who will decide that? That will be decided by the speaker. Okay, and now the provision says that the speaker's decision over here will be final and it will not be questioned in any court of law. Okay, but there has been precedences or the cases wherein it was said that it is also under the judicial review, and that is why this particular scene you can see over here, wherein this question can be raised in the you can say Supreme Court. Okay, now coming to the you can say money bill. In India, a money bill is a type of legislation that relates to the appropriation of money from the Consolidated Fund of India, which is the main fund of the government. Now, basically, with the name, it is clear that it is a bill which is related to money matters. Okay. Now, there are certain things which are given in the, you can say, Article 1110 of the Constitution, which has actually you can say lined up certain topics which are related to the money bill. Okay, so we'll be talking about that, but in simple words you can say that if there is a money which is being appropriated from the Consolidated Fund of India, yeah, if we are taking out money from that particular fund, okay, so in that case, if that matter is related to money, taxes, etc., then these are money bills. Okay, but there are certain exceptions, we will talk about that as well. Okay, money bills are typically related to the financial matters such as taxation, public expenditure and the public debt. Okay, taxation means that basically the money is coming to the fund, that is consolidated fund of India or contingency fund of India, which is under the president. Okay, in such cases when money is coming in, that is by the way of taxation or by the way of borrowing. Okay, so that is financial matters. Or second thing is expenditure, money which is going out of that particular fund. Okay, so for that expenditure you have to go for the appropriation. Okay, in the parliament there is an appropriation bill which is to be passed, and then only you can take out the money. Okay, so these matters are basically related with the money bill. Now what are the constitutional provisions here? So you can say article 109 and 198. When we are talking about 109, this is related to the parliament, and 198 basically related to the state assemblies. Okay, so right now we will be focusing on the 109. Then when we are talking about the 109, it is talking about the procedure. Okay, with a special procedure in respect to the money bill, that is there. And when we are talking about the 110, that is 11 or 110 article number, and there is another article that is 199, that is related to the state assemblies, and this is related to parliament. Okay, now 110, it deals with the definition of the money bill. Now what is the definition which is given in the 110? So there are certain heads which are given over here. A bill is deemed to be a money bill if it contains only provisions dealing with following. Okay, now here you will see, first is imposition, abolition, remission, alteration, regulation of any tax. First thing we have seen in the previous slide that taxation is one of them. Okay, so that is there. Second, regulation of the borrowing of the money by the union government. Okay, so borrowing, which we have already talked, by borrowing you are adding money to the consolidated fund of India. Okay, so that is there. Second, third is appropriation of the money, payments and the withdrawals from the consolidated fund of India or the contingency fund of India. So basically here these are the ways we are actually putting money in the consolidated fund, and this is the way appropriation of the money, taking out the money or the public expenditure. These are the matters which are also related to the finances, and we are taking money out of the consolidated fund of India or the contingency fund of India, which is under the president. Okay, now receipt, custody, audit of money on account of the consolidated fund of India or public accounts of India. Okay, so basically these are all matters which are related to money matters or any matter incidental to any of the matters specified above, or any matter which is basically related to such matters which are given in the following heads. So basically such bill will be deemed as a money bill. Okay, now which of the bill are not money bill? Okay, so a bill is not deemed to be a money bill by reasons only that the provision provides for the imposition of the fines or other pecuniary penalties. Okay, fines, penalties, small amounts are not related to your money bills. Then here you will see demands for payment of the fees for license or the fees for services rendered, etc. So any kind of fees, if there is, okay, so matters related to that fees or fines or the, you can say, penalties, these are not considered matters of money bill. Then imposition, abolition, remission, alteration or the regulation of any tax which is imposed by the local authority or body for the local purpose. Okay, in such cases also such taxes will also be will not be part of your money bill related provisions. Okay, so these are three things which are not part of your money bill. Okay, otherwise we have discussed these things which are basically you can say forming parts of money bill. Okay, now moving further, what are the roles of institutions with respect to the money bill? Lok Sabha. First, when we are talking about the Lok Sabha, as I told you, money bill will be introduced in the Lok Sabha. Okay, there will be a prior, you can say, permission which has to be taken by the speaker. And when we are talking about the money bill in respect of the money bill, Lok Sabha speaker will decide whether it is a money bill or not. Okay, so the role of speaker here, you can see the speaker of the Lok Sabha has to certify that the bill being introduced as a money bill. Okay. Second is his decision in this regard cannot be questioned in any court of law or in any house of the parliament, either house of the parliament or even the president. No one can question the decision of the, you can say, speaker. However, Supreme Court of India in 2018, while delivering a judgment upholding the Aadhaar Act, stated that the speaker's decision will be subjected to judicial scrutiny. Okay. So in that particular case wherein Aadhaar Act, the constitutional validity of Aadhaar Act was challenged, and at that point of time Supreme Court has said that the decision of the speaker with respect to the money bill, that is also under the judicial scrutiny. Okay, so that is a judicial precedent. When a money bill is transmitted to the Rajya Sabha for the recommendation and presented to the president for the assent, the speaker endorses it as a money bill. So when you are sending the bill to the Rajya Sabha, then the speaker will say that this is a money bill. Now you have a limited powers over there. Okay. Now when we are talking about the role of Rajya Sabha, so in the matters of money bill, Rajya Sabha does not have very huge role, or you can say they have only a limited role. Okay, money bills cannot be amended or rejected by the Rajya Sabha. Rajya Sabha can only discuss them. Rajya Sabha can only discuss them. They can suggest any kind of you can say amendments. Only they can suggest amendments. Okay. Now, when this bill comes back to the Lok Sabha can accept these amendments or they can reject it. Okay, that is there. Or Rajya Sabha cannot sit on it. Okay, so basically you have to reply within the 14 days, and if you are not doing that in the 14 days, that means that they will deem it as passed by Rajya Sabha. Okay. Now, coming to the president, after Lok Sabha, after Rajya Sabha, the bill will go to the president for the assent. In that case, it can be rejected or approved. President can reject it or approve it, but cannot delay the process, cannot you can say keep the bill. Okay, so that is there. Second thing is that he cannot go for the reconsideration. Okay, president, you know that when we are talking about the ordinary bills, president has certain power. President can give the assent, president can withhold the assent, or president can send it back for the reconsideration. But in the case of money bill, president cannot send it for the reconsideration. I hope that is clear. Now, moving further, joint sitting. You know that whenever there is a deadlock, okay, in the case of deadlock, speaker can call for the joint sitting. Okay. Now, when we are talking about the joint sitting, that is to remove the deadlock. When we are talking about the money bill, there is no provision for the joint sitting. Okay, because obviously we know that Rajya Sabha does not have very much power, or they have limited power. Okay, so passing by the Lok Sabha is something which is important. Okay, so if Lok Sabha passes it, that's there. Otherwise, there will not be joint sitting because Rajya Sabha anyways has a limited role. Okay, so that is there. When we are talking about the constitutional amendment acts or the bills, at that point of time, you know that in even the constitutional amendment bills do not have a provision of the joint sitting. Okay, so that is about money bill. Now, we will see what are the issue with respect to it, why the Supreme Court is hearing it, because when you are saying that speaker will decide whether it is a money bill or not. Okay, so now speaker can decide on any bill if they want to, you can say circumvent the scrutiny by the Rajya Sabha, and if they are saying that it is also a money bill, it is also a money bill, in that case role of Rajya Sabha will be limited. Okay, so that is one issue which is there. Other than that, here you will see there is alleged misuse of the money bill route. Okay, in the case of Aadhaar Act, okay, Aadhaar Act was basically related to Aadhaar, UID, etc., but they have passed it as a money bill. Okay, so now there was this question that why they have passed it as a money bill. Okay, second thing is amendment to the Prevention of Money Laundering Act in 2002. Okay, so basically the provisions of the amendments were not basically related to the taxation or etc., and that is why even then they have actually passed it as money bill. So that is why they are saying that there can be alleged misuse. Okay, now we are not saying that they have misused it, but the thing is the opposition has said that there are some allegations with respect to the you can say this route which has been taken by the government of the day. Okay, now it limits Rajya Sabha's role in lawmaking, which we have already discussed. Anything can be passed as money bill because that is on the discretion of the speaker. Okay, and hasty lawmaking. If we are saying that if we are not going for the Rajya Sabha scrutiny, that means that Lok Sabha has the power, and speaker, if Lok Sabha has the majority, so in that case there can be hasty lawmaking as well. Okay, so that is the issues which are related to money bill. We have talked about the definition, issues related to it, etc., etc. Okay, and we'll be waiting for the judgment with respect to this thing of the Supreme Court. Okay, now moving further to the next article, which is related to your basically judicial review. Okay, now as I told you that the speaker has a specific power with respect to the money bill, that he will decide on it. Okay, so whether this decision of the you can say speaker, that is under the judicial review or not, that was the question, and because of which we are talking about the judicial review, because we have seen that in 2018 in the Aadhaar Act, the court has said that the decision of the speaker is also under the judicial scrutiny. Okay, so what is judicial scrutiny? How will they scrutinize? That is basically the power of judicial review. Judicial review is nothing but that court will actually scrutinize a particular action which is taken by the executive or the legislature. When we are talking about our governance system or the our polity, you know that there are three organs which are there when we are talking about the governance. That is, one is executive, second is legislature, third is basically judiciary. Now these three elements or these three organs of the government, they are basically keeping a check and balance on each other. Okay, now judiciary's way of putting a check and balance is basically judicial review. If executive or the legislature, they are doing something which is not in favor of the law, or which is against the constitution, in that case they can go for the judicial review. Now, if we are talking about the executive, you know that there is the Article 32, which are basically writ jurisdiction. Other than that, Article 226 is there, wherein High Court can issue writs. Okay, so if executive is doing something which is against the law, in that case, the Supreme Court or the High Court can go for the you can say issuing of the writs. That is basically a kind of judicial review. Second is when we are talking about the legislature. So if legislature comes with a law which is in the countervention to the constitution, in that case there is this Article 13. Any law which has been passed by the legislature cannot be against the constitution. Okay, so from that you can say that we have derived the concept of the judicial review. Okay, so that is there. Now coming to the judicial review, what is that and how it is done? Okay, now definition, if we see the court proceeding wherein a judge reviews the lawfulness of a decision or action made by the public body. Now in public body can be executive as well as the legislature. Okay, second thing is it challenges the decision making process rather than the conclusion itself. Okay, so basically here when we are talking about the definition of the judicial review, this is nothing but the thing is they are basically putting a check and balance on the you can say other two organs of the government. Okay, now what is the concept of law? We are saying that if they are legislature is passing any law, okay, which is against the constitution, so what is that particular law? Okay, how it can be against the constitution? That is there. Okay, second thing is if executive is going against the law. Okay, so these are the two factors wherein you can go for the judicial review. Now the thing is, how will we decide that whether law or the action taken by the legislature or the you can say executive, that is against the law or not? Okay, so basically there are two things: procedure established by the law. If there is a law and there is a procedure given and that procedure is followed, even if that law might not be right, or you can say that a law might not be rational or the reasonable, but the procedure has been followed, that means that you can say that is not against the law. Okay, so basically let's say in India we have a provision of the capital punishment. Okay, now taking a life of a person is not a moral thing to do. Or if we are talking about, you can say Article 21, right to life is there. Okay, so we can say that it can be against the you can say right to life, but the thing is there is a procedure which has been put in the law, that is in Article 21 it is written that there is a right to life and personal liberty. Okay, and the thing is that is as per the procedure established by law. Okay, if there is a procedure, let's say if there is a crime which is heinous in nature and for that capital punishment is given, that means that there is a procedure for that, and if that procedure is followed, that means that you have followed the law. Now in that case it is not against the fundamental right of a person that you have taken his life. Okay, so that is one thing. Second thing is due process of law. In that case, not only the procedure but the rationality of the law, whether the law is right or not, that is also being checked. Okay, but in India we follow the procedure established by law. But when we are talking about the various judgment of the Supreme Court, there is this 𝐸𝐻𝐒 𝐏𝐫𝐞𝐥𝐢𝐬 judgment which says that in spirit, when we are in letter we follow procedure established by law, in spirit we follow due process of law. Okay, but the thing is just the concept, these two concepts are important for you. You can go through your notes and read about these two concepts. Now coming to the next part, that is basically the function. When we are talking about the judicial review, why it is important, here you will see ensures actions of the legislature, executive and the administrative bodies conform to the constitution. Second is legitimate government actions and protect the constitution from the undue encroachment. So basically they are protecting the law, they are protecting the constitution. You know that constitution is the law of the land. Okay, now they are trying to protect the constitution so that no executive or any body of the legislature, any public body or any executive body, any legislative body, they do not encroach on the constitution. So that is why we are going for the judicial review. Okay, now types of the judicial review. Here you can say legislative actions ensures law comply with the constitution. Okay, if there is a legislative body which has actually encroached or you can say or they have gone beyond the constitution, in that case Supreme Court can go for the judicial review and then they can say that this is against the law and that is why this is null and void or the unconstitutional. Okay, so that is legislative actions against which there is a power of judicial review. Then administrative actions. Okay, administrative body, if they do something like that which is against the law, in that case also Supreme Court can you can say thrash that particular order by issuing any kind of writ under Article 32 and High Court can do it under Article 226. Okay, then judicial decisions. Now how Supreme Court will go for the judicial review of judicial decisions? Basically you know that Supreme Court is a court of record, and the Supreme Court has power to, review its own judgment. Okay, so that is how this is the third type. Okay, so I hope that is clear. Now, moving further, what is the importance? Obviously, it will ensure that there is a constitutional supremacy or the law is followed. Second is check legislative and the executive actions. Okay, protect people's right, maintain federal balance, secure judicial independence, prevents executive tyranny. Okay, so these are basic things which you can say go through. Okay, now if we are looking at the problems, what are the problems? Obviously, if there is a over judicial overreach, or you can say that over judicial activism is there, that means that there is an overreach in the arena of the legislative and the executive. Okay, so basically here what I'm trying to say is that when we are talking about the executive's work, when we are talking about the legislative's work, and when we are talking about the judiciary's work, so these are having some kind of overlapping. Okay, but the mostly you will see that there are certain, you can say, powers which are only with the judiciary. There are certain things which are to be done by the legislation. That is, one thing is law making. Law making is only prerogative of the legislative. Now, if judiciary is coming out and they are saying that you have to make a law on this particular thing, and this is how you have to make a law. Okay, in that case, you can say that that is outreach, or you can say that is too much activism which judiciary is showing. Okay, or that you can say that judiciary is taking control in their hands. So that is one thing which can be a problem over here. Okay, that is judicial outreach. Okay, here you will say limit government functioning. Okay, now how it is limiting the government functioning? If government is coming up with a law which is against the constitution, okay, or let's say which is not in favor of judiciary itself sometimes. Okay, there was this law that is related to basically National Judicial Appointment Commission. Okay, and judiciary has actually made or you can say discarded this particular amendment because that they have said that it is against the independence of the judiciary. Okay, so you can say that because of the judicial review, there is an extra power which is with the judiciary. Okay, other than that, if we are talking about you can say judicial review, the discretion which is with the judiciary. Okay, when we are talking about the basic structure, when we are talking about you can say certain arenas which are not being defined by the constitution, so wherein Supreme Court has the you can say upper hand to decide, or you can say interpret the constitution. Okay, so obviously because of which there can be an extra power, or you can say unbalanced situation can arise if too much power is given to the judiciary. But the thing is, again, legislature and the executive also has some kind of check and balance on the judiciary as well. Okay, so that is about the you can say judicial review which we have seen. Okay, what are the constitution provisions which are related to judicial review? We have talked about the Article 13, we have talked about 32, we have talked about 226. There is Article 245 which is power of parliament and the state legislature subjective to the constitutional provisions. Then Article 131 to 136, these are the articles which are related to the powers of the Supreme Court, which is there. So court's power to adjudicate disputes and interpret the constitution. And Article 137, Supreme Court's power to review its own judgment, which we have seen. Okay, so that is there. Now coming to the next topic, which is basically your collegium system. Okay, so when we are talking about the collegium system, you know that recently 2 judges has been appointed. Okay, now when we are talking about the appointment of the judges in the higher judiciary, when we are talking about the judiciary, there are, you can say, one is your when we are talking about the judiciary, you know that there is this hierarchy. First is Supreme Court, then we have High Court, then we have the subordinate courts. Now when we are talking about the subordinate courts, these are the district courts, sessions courts, these are there. Okay, civil courts. Now the appointments of the judges in this particular level, that is through the examination, and this is under the you can say supervision of the High Court. Now appointment of the judges in the High Court and the Supreme Court, that is done by the process of collegium system. Okay, now collegium has been a process wherein judges are appointing the judges. Okay, so basically there are certain positives, there are negatives, and so we'll be talking about that collegium in this particular discussion. Okay, now here you will see the first thing, the elevation of the Justice Koteshwar Singh and R. Mahadevan was approved only a day after the Supreme Court's collegium recommended the both judges' name. Here Supreme Court, the collegium has recommended the name. So one thing is clear, that collegium will recommend the name, and these names will be given to the law ministry. Law ministry will give it to the PM. PM will recommend it to the president, and then president will go for the appointments. Okay, so that is the procedure which is to be followed. Now what is collegium system? It is a system of appointment and the transfer of the judges that has evolved through the judgment of the Supreme Court and not by the act of parliament or the provisions of the constitution. Now here you will see that there is this article, that is Article 124 in the Indian Constitution, which talks about the appointment of the judiciary or you can say judges, and that is to be done by the president. Okay, but they have only said this much only. There is no procedure which has been given over here. Okay, there are certain words like consultation in the with the consultation of the Supreme Court's CGI, etc. But the thing is, they have not given the procedure. Now, how this procedure has came, that is on the basis of the Supreme Court judgment. Okay, there was this first judge case, that is 𝐻𝐾 𝐏𝐫𝐞𝐥𝐢𝐬 case, then there was second judge case, there was third judge case, and through which this collegium system has came into picture. Okay, what is collegium system? That is, judges basically are appointing the judges over here. Here you will see the constitutional provision related to the appointment of the judges, that is given in the 124 clause 2 and 270. That is basically related with your, you can say, appointment of the judges in the Supreme Court. Okay, the appointment of the judges of the Supreme Court and the High Court, the president makes appointment after the consulting with such judge of the Supreme Court and of the High Court as he or she may deem necessary. So basically they are saying that in the consultation with, okay, so president will consult with the whoever be it the judge of the Supreme Court or the High Court or the CGI. Accordingly, he will consult with them and come up with the name of these people. Now, this particular issue was started with the word consulting. What is the interpretation of the word consulting? Okay, whether it is consulting only or whether these consultation is binding or not. Okay, and that is how came the case, that is 𝐻𝐾 𝐏𝐫𝐞𝐥𝐢𝐬 case, that was in 1981, I guess. At that point of time, this case was came into picture, and that was the first judge case. We'll talk about that. But the consultation does not lay down any process for making these appointments. So basically here, the process was not there, and that is why with the various cases of the Supreme Court, we have come up with the procedure, that is basically collegium system. Okay. Now, evolution of the system, we see how it came. So as I told you, there was this first judge case wherein this word consultation, which is given in the article 124, which has been discussed, that whether this consultation is binding or not, whether this consultation is just consultation or the coherence. Okay, so basically in that case, Supreme Court has said that this is just consultation, this is not binding. Okay, so here you can say that the president has been given the higher power. Okay, so executive's role was way more when we are talking about the first judge case. Then coming to the second judge case came in 1993. Okay, at that point of time, again they have come up with this particular same thing, consultation or the coherence, or you can say it is binding or not. In this case, they have said that yes, it is binding on the president. Whatever consultation the you can say Supreme Court is giving, that is basically binding on the you can say basically president. And second thing is that whether the consultation by the CGI, that is only the CGI's consultation or someone else will also be there. Okay, because the word which is written is that you can say here when we are talking about the constitution's provisions, here you will see consulting with the such judges of the Supreme Court and the High Court that he may deem necessary. So basically they are asking that whether the Chief Justice opinion is all right or someone else also should be considered. Okay, so in the second judge case, they have said that there will be Chief Justice plus 2 judges. Okay, and their opinion should be consulted with. Okay, then comes the third judge case that was there. In third judge case, it was said that the collegium size was expanded, that this would be CGI plus 4, and these 4 judges will be the senior most judges of the court. Okay, so basically when we are talking about the third judge case, or you can say when we are talking about the second judge case, that is when the collegium system that is came into picture. Okay, and the present form of the collegium that came into picture in the third judge case. Okay, I hope that is clear. First judge case is also known as 𝐻𝐾 𝐏𝐫𝐞𝐥𝐢𝐬 case. Okay, I hope that is clear. Now moving further, current structure if we talk about, so when we are talking about the Supreme Court, there are Chief Justice plus 4 senior most judges. When we talk about High Court, there are Chief Justice plus 2 senior most judges of Supreme Court. Okay, so here one thing which is important is that you have to take the you can say judges of the Supreme Court only. Okay, now what is the criticism? What is happening inside the collegium? No one knows what is happening inside the collegium, how these discussions are being taken place, etc., etc. Okay, so that is there. That is why there is an opaqueness in the collegium. Okay, scope for nepotism. Okay, since judges are appointing judges, there are chances that they will go for the favoritism, nepotism, etc. Okay, exclusion of the executive. Now, since they said that the you can say consultation, the word consultation is basically binding, or you can say the whatever name which are being given by the Supreme Court to the executive, that is binding on the executive. That means that executive have very limited power. Okay, whatever names they are given, executive can send them back for the reconsideration one time, but again if they are sending it back to the same name, they are sending it back to the executive, then president has to appoint those people as the judges. Okay, so that is there. No predetermined procedure for the appointment. Okay, as I told you, there is no procedure which is there. It is just based on the Supreme Court's judgment. Okay, so that is about these you can say collegium system. Now after the third judge case, there was another case, or you can say there was this constitution amendment which was there, and on the basis of which we have come up with the 99th Constitutional Amendment Act 2014, in which they have come up with the National Judicial Appointment Commission, that is NJAC. But you will see that Supreme Court actually has struck it down. They have said that it is unconstitutional because it is basically intermingling with the independence of the judiciary, because they are increasing the role of executive in the appointments. Okay, so with that, this is also known as the fourth judge case, but ultimately they have actually struck it down. The 99th Constitutional Amendment Act 2014, which provides for the NJAC, that is National Judicial Appointment Commission, basically they have struck it down. Okay, so right now still, if we are talking about the present case, we are relying on the collegium system. Okay, now moving further, that is next and the last, that is basically Gram Nyayalayas. You know that our judiciary, there are various cases which are pending, and judiciary is overburdened. You can say there is a delay in the justice system, etc., etc. Access to the justice is very you can say less. Affordability is very less, because you can say when we are talking about the higher judiciary, the cost is increasing. All these things are there. Okay, and that is why, to remove all these obstructions to the justice, basically they have come up with the various ideas like Gram Nyayalaya, like Lok Adalat, so that there can be a speedy, you can say, justice delivery. Okay, so that was there. With respect to that, the concept of Gram Nyayalaya was there. We will be talking about that. What is it? So here you will see that Gram Nyayalayas are the village courts for the speedy and the easy access to the justice delivery system, or you can say justice system, in the rural areas of India. These are the areas which are, you can say, remote areas, or you can say hinterland areas, or the villages wherein you can say awareness is very less. So most of the time you will see that the issues are given to the panchayats for the, you can say, to sort it out. But the thing is, those people who cannot go to the court can come to them. That is the concept of basically Gram Nyayalayas. Okay, the Constitution of India, in under Article 39A, mandates for the free legal aid to the poor and the weaker section of the society. Basically here they are talking about the access to justice. Okay, 39A, that is part of your DPSP. Please remember that. The Law Commission of India 114th report, they have also actually recommended the establishment of the Gram Nyayalayas. Okay, on the recommendation of that, in 2008 we have come up with a law, that is Gram Nyayalaya Act 2008, and which provided for the, you can say, Gram Nyayalayas. Okay, so initially it was targeted that nearly more than 5,000 Gram Nyayalayas will be set up, but as of now there are only 200 to 300 which are operating, and that is why looking at the effectiveness of this particular procedure, Supreme Court has directed the states to put forward a report on the effectiveness and the, you can say, working of the Gram Nyayalayas. Now, salient feature of the Gram Nyayalaya, if we are talking about the establishment, we have seen that there was this act, that is 2008 Act. Okay, each Gram Nyayalaya is the court of judicial magistrate of the first class. Okay, then there is a Nyayadhikari, or the presiding officer, that will be appointed by the state government in consultation with the High Court. Okay, appointing authority is governor. Okay, but the thing is, the name will be suggested by the state government with the consultation of the High Court, established for every intermediate panchayat. Okay, so at the panchayat level or the group of panchayat level, they will be established, located at the headquarter of the intermediate panchayat, and conduct mobile courts in the villages. Mobile courts means, as I told you, that if the person cannot go to court can come to the village. Okay, so that is there. Now moving further, jurisdiction will be decided by the state government in the consultation with the High Court. Pecuniary jurisdiction or the monetary jurisdiction will also be decided by the High Courts over here. Nyayadhikari can hold mobile courts and the conduct proceedings in the villages. And the, you can say, if we are talking about the kind of matters or the, you can say, nature of cases, that can be both civil as well as criminal, and these are given in the, when we are talking about the criminal cases, first schedule of the act, and the, when we are talking about the civil cases, second schedule of the act, which has been which has given about the list of the matters. Okay, now pecuniary jurisdiction or the monetary jurisdiction, which we have already said that it is decided by the respective high courts. High courts can transfer eligible cases from the district to the Gram Nyayalayas if they deem it necessary that this case can be sorted out in the Gram Nyayalaya. High Court can transfer it. Okay, so aim to settle the disputes via conciliation. So most of the time you will see that the parties can come up with a kind of agreement, and there will be a conciliator. So basically that will talk it out the issue. Okay, so that is the idea of, you can say, Gram Nyayalayas. So how these can help? As I told you, there is an overburdened judiciary. Okay, so to speed up the process, that can help. Here you will say devolving justice deliveries to the grassroots level, because we are working at the village level, that is there. Then ensuring equal access to the justice, which we have already discussed. Reducing the burden on the district courts, delivery speed. You can say they are speeding up the justice system, lowering litigation cost for the common people, reducing dependency on the extra constitutional forms of the justice. Okay. Then what are the operational challenges? Lack of the infrastructure, because since they are in the villages, so there are chances that the infrastructure might not be very much built over there. Then when we are talking about the manpower in the villages, the manpower will also be less, because notaries and the stamp vendors, they are mostly at the district level. Okay. Then inadequate central assistance, which is there. Lack of awareness among the lawyers and the police. State functionaries reluctant to invoke Gram Nyayalayas jurisdiction, and dependence on the taluka level legal you can say service institutions. So basically there are infrastructure related problems which are faced by the Gram Nyayalayas. Okay, I hope that is clear. Now moving further, we will be taking up a test. There will be 2-4 you can say questions which we have to you have to answer in the comment box. First question is, which article of the Indian Constitution defines money bill? Article 110, 112, 117, 123. So you can attempt this question and answer in the comment box. Question number 2 is basically related to your judicial review. The power of judicial review is vested in President, Parliament, Supreme Court and the High Court, and the Prime Minister. Okay. Question number 3. For the appointment of the High Court judges, the Collegium consists of the Chief Justice of India and 2 senior most judges of Supreme Court, 3 senior most judges of Supreme Court, 4 senior most judges of the Supreme Court, 2 senior most judges of the concerned High Court. Okay. So that is about the, you can say, Collegium in the with respect to the Chief Justice of High Court, with respect to the appointment in the High Court. Okay, so that is there. Now moving further, question number 4. Gram Nyayalayas has jurisdiction over which type of cases? Only civil cases, only criminal cases, both civil and criminal cases, only constitutional cases. Okay, so I hope that is clear. So you can attempt all these questions and answer in the comment box. If you have any kind of doubt, you can put it in the comment box. With that, I would like to wrap up the session. If you have not subscribed the channel, please subscribe it. Have a nice day. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.